Well, hello there once again, Employment Law Show. Good to have you with us. John Scholes here with me, of course, Lior Samfiru, employment lawyer. And you want to reach out to Lior anytime, you can do so. I'll give you the phone number right off the top, 1-855-821-5900, help@employmentlawyer.ca. You can just go to employmentlawyer.ca as far as the website is concerned for much more reading, learning, and contact information as well. We'll also get into a little website called pocketemploymentlawyer.ca. What has that got on it? It's got everything you need to know about employment law. You should be well educated in that regard. Even before the phone call to Lior, you can go to that website. You'll also have free and anonymous access to the Severance calculator, with over 2 million people having done what I just told you to do, and check out what their severance should be. On the show today in just a bit, 5 employment law myths, common myths. We're going to get to those in just a bit. We got some phone calls from our live radio shows that we do across the country. You'll have an opportunity anytime to listen to those radio shows. Go to employmentlawyer.ca to find a station near you. That and so much more, brother. But we always start off with the week that was, a little something that's been happening with you, Lior. What do you got, pal?
John, great to be here. Great to talk employment law. Great to help our viewers understand their rights. We all work. Employment law impacts what we do in our job. Hopefully other laws don't interfere with us too much, but employment law is important. It governs what we can do, our rights. So if you always wanted to know if what your employer is doing is legal, if their policy that they've implemented is legal, can they enforce it? If you're owed more, if you were let go, what to do if you're mistreated, what to do if you're an independent contractor, but you're not sure if you are. We talk about those things on the show, on every show, to inform you, to educate you, and to help you understand what those rights are. And of course, if what we talk about today, rings a bell or maybe raises more questions in your mind, very easy to do. All you have to do in that case is reach out to me in the office. We'll give you that contact information throughout the show, so you can call, you can email, we can have that discussion. And of course, John, now that we know what we're here to do, let's do it. Let's talk about at least one situation that came across my desk. I spoke with a gentleman who was in a very senior role with his employer, and unfortunately for him, only made it there for about 6 months. And after 6 months, he was let go. Now, when he was let go, his employer offered him 5 months severance. And this person, to be honest with you, and his friends, his family members, all thought, that's a pretty darn good offer. You've worked there for 6 months. Yeah. You were offered 5 months severance. But he watched this show and he realized, you know what, just peace of mind, let me call Lior. Let me understand if the offer that I'm being given, 5 months severance after 6 months, is it really that good, or is there something that I'm missing? So I talked to him, and I learned one key piece of information when I talked to him is, yeah, he was only there for 6 months, but before he worked there, he worked at another company for 12 years, and he was recruited from that company through a headhunter. Well, why is that important? It's important because in a situation when you're recruited from another company, only to then be let go, you're owed enhanced severance that recognizes your time with the previous company. So in this situation, even though he only worked for 6 months, for legal purposes, for severance purposes, he was a 12-plus year employee. So I assessed him as being owed as much as 18 months of severance. 18 months! That's more than 3 times what he was offered. And again, he only worked for this company for 6 months. I'm glad he called me, and I wanted to bring this up here today for a couple of reasons. Number one is this concept of being recruited away. We call that inducement. If you are recruited away from another company and then you're let go, you could be owed enhanced severance, which could be huge. It could be massive. But there's another reason here is you may not understand or appreciate the source of your entitlements if you're let go. You may think it's straightforward. Well, if I'm let go, I'm owed this much. It's not. Oftentimes, there are reasons, there are other ways where you can get a lot more than what you believe. That's why you make that call. Even if you think what you've been offered is appropriate, even if your best friend, your significant other tells you that's a good offer, don't make a mistake. Don't make a mistake that's going to cause you to lose sleep. Be certain, make the call, and let's talk exactly about what you're owed.
I guess the linchpin for this whole thing was the fact that he didn't go knocking on their door. They said, hey, come on, we got a great gig for you. Why don't you come join us? That's the big part of it, right?
Well, to be even more specific, a headhunter, a recruiter knocked on his door and said, hey, we know you work here, you have all this great experience. We want you to come work for this company. And that recruiter as an agent of the new company,
Right.
is really recruited him away. He wasn't looking to leave. He wasn't shopping out his resume. And because of that, now that he's let go, they have to recognize that past service. Massive, John. Imagine working for a company for 6 months and then being owed 18 months severance. That's his situation.
So let's take it now for a moment from the employer's side, and they learn this and they're like, ooh, okay, that's a lot more money we owe. How could they have avoided that issue?
Very simply, all they would have taken is one line in his employment agreement saying that we're not recognizing any past service. Full stop, done, move on.
Wow.
They didn't do that, lucky for him, but there's also an important lesson there for employers and employees, depending on your perspective. Be watchful. Keep in mind that employment agreement. We'll talk more about employment agreements, but be mindful of the fact that that employment agreement can impact your legal rights as an employee. So when you sign an employment agreement, don't just look at your salary and vacation. Pay attention to everything, or even better yet, send me a copy and I can tell you what it says.
I didn't mention, pardon me, off the top of the show that we do a radio show. We've done them across the country for whom we're coming up on 10 years. Everywhere outside of Quebec, you'll catch that show. Just go to employmentlawyer.ca. There's a Knowledge Center tab along the top, drop down media, and you'll find a station near you. It's good because we get a ton of calls every week from across the country, and sometimes we like to play them back here and talk about them because they're always informative and educational. So we'll get to the first radio show call coming up right now.
Well, I was at an employer for 18 months selling marine parts. So they hired a younger gentleman to help me out. After the younger gentleman had learned everything, he surpassed my abilities on the computer. They terminated my position and kept his position. Gave me 2 months severance and said, see you later.
And how old are you?
I'm in my 60s. I was with that employer for 18 months.
Yeah.
Well, the first thing I want to address here is the fact that he says that he was let go for a younger employee. Now, maybe it's just the circumstances, or maybe it's a deliberate thing on the part of his employer to say, you're too old, we're going to hire someone younger. That's age discrimination. You cannot be let go because of your age, full stop, whether you're 60, 70, 80, any other age. Our human rights laws make it clear that age should not even be a factor. Not even a factor in deciding whether you lose your job or penalize in any way, shape, or form. So right off the bat, if he says, well, they thought I was too old, I would want to explore that issue and say, is there a human rights violation? The second issue, of course, what he was calling us about is the severance. So we know that this guy worked there for a year and a half, and he was offered 2 months severance. Now, for most people, John, that may seem okay. That's like roughly about 6 weeks per year of service.
Yeah.
It may not sound bad. Well, guess what? It's not adequate. It's not even close to being adequate. So rather than me just tell you how much he's owed, let me show you how you can find out yourself how much this person is owed, how much you're owed. We're going to go, as usual, to our severance calculator, which you can find at pocketemploymentlawyer.ca. Let's take this person information and let's see how much severance he is actually owed. So we know that he's been there for about a year and a half, older gentleman in his 60s, and was offered 2 months of severance. Well, you see right there on the screen that he's actually owed 6 months of severance. John, that's 3 times what he was offered. Yes, a year and a half, he gets 6 months. It's as simple as that. That's why, even in a situation, I've said this at the beginning of the show, where the offer that you get seems to be appropriate, it seems to be even generous, chances are that it's not, because the law is even more generous than that. That's why you have to give me a call or go to pocketemploymentlawyer.ca.
And including to this TV show, all the radio shows across the country, and now live streaming as well. Sometimes he practices law. We're not sure when. We're actually going to find that out one day, but Lior does a ton of that as well. YouTube and Facebook, you can tune into the live stream. In fact, you contribute, stlawyers.ca, stlawyers.ca if you want to do that. Let's get to a question from the live stream. Lior says, I'm about to start a new job in a management position at a fairly large company. I was offered a contract to sign. Is there anything I should be looking out for in this contract or be aware of? That's what we're talking about.
We're talking, I mentioned we're going to talk about contracts briefly, so for sure, if you're going to be taking on a new position, especially a senior position, salary obviously is important, you're going to look at that. Vacation is important, bonus, you're going to look at that. But here's a few other things you want to look at. Is there a term there that limits your future severance? Yes, you have to think about severance now, because if you don't care now, you'll care later. You could potentially be agreeing to something that's going to cost you tens of thousands of dollars later on. So is there something that affects your future severance? Is there a term there that allows the company to put you on a temporary layoff? Again, most employers are not allowed to put you on a temporary layoff. It's not legal unless you sign an employment agreement that gives them that power. Is there a term there that allows the company to change your job, to change your hours of work, to change your compensation? If any of those are in the employment agreement, that's a problem. Your employer then can essentially do whatever it wants and you don't have any recourse, so pay attention to that. Is there a non-competition obligation, something that's going to prevent you from earning a living down the road? So those are just a few examples of things that you need to look out for anytime you sign an employment agreement, whether you've just accepted a job, whether you're already working and you've been offered a job, whether it's a senior or a junior position. Be very mindful of those things, and the best advice I'm going to give you is let me see it. Let me tell you what it does, and we can then talk about how we negotiate.
As we mentioned off the top of the show, 5 common employment law myths. That is our main topic for the show today. We'll get to that in just a moment, but we'll take a short break and get right back to it. In the meantime, that number, 1-855-821-5900, help@employmentlawyer.ca, and always, pocketemploymentlawyer.ca as well. Stick around, lots more coming up. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. Good to have you with us, John Scholes. And of course, Lior Samfiru can be found anytime at employmentlawyer.ca, the website. Just put a help at in front of that for email and the phone number, 1-855-821-5900. Always like to dig deep into a topic each week on the show that's always pertinent information that you should know going forward in your work life, because you spend 1 billion hours of your life at work, right? More than anything else you do. So this week we're doing 5 common employment law myths. Number 1, Lior, a wrongful dismissal occurs when an employer lets you go without a legitimate reason. Break that down.
John, there's no area of law that has as many myths or misconceptions as employment law. People read something online, they talk to someone, they believe that they know, they make assumptions. And I hate assumptions in these situations, because the easiest way to give up your rights or to be ignorant of your rights is to make assumptions. So that's why we're here, to tell you the truth, to tell you what you need to know, to educate you on the actual law, not what we think or you think the law should be, what it actually is. And we're talking about a few myths, and John mentioned one of the most common one, which is that a wrongful dismissal has to do with the reason you were let go. So let's break this down. An employer generally can let you go for any reason or no reason, as long as severance is paid. So you may think my employer has a bad reason, I got a good performance review, so they don't have a basis to let me go. And I agree with you that from a business standpoint, from a moral standpoint, your employer should not do that. But here we're talking about the law. And from a legal standpoint, your employer can let you go, even if you've done nothing wrong, as long as severance is paid. Oftentimes, I see a situation where the employer may want to bring in a friend of theirs, hire that friend instead of this person in the job, and they let the person go. That's not fair, but legally, they can do that as long as severance is paid. So what is then a wrongful dismissal? A wrongful dismissal, therefore, has to do with severance. If you've been let go and you haven't been paid or offered your full severance, you've been wrongfully dismissed, regardless of the reason. We don't even need to talk necessarily about the reason. If you've been let go and that severance is not appropriate, that's a wrongful dismissal. And here's the thing, over 90% of people, when they've been let go, they have been wrongfully dismissed because the severance is not adequate in almost every case. So if you lost your job, whether it's today, last year, 10 years ago, chances are that was a wrongful dismissal, because you may not have realized that you're owed a lot more severance than what you're owed. So to find out that severance, we've talked about that. You can always call or email me. You can use our severance calculator at pocketemploymentlawyer.ca. But remember, the reason doesn't really factor in.
It's that word wrongful. That's what's throwing everybody off.
It's suggested that dismissal is wrong, whereas really what's wrong about it is the severance paid as a result of the dismissal. Right. So the reason doesn't factor in. Now, of course, there's an exception to that. You can't be let go for discriminatory reasons, for example. Yep. You can't be let go because of your age or your disability or your ethnicity. That's a human rights violation. No severance is going to fix that. But if it's not a discriminatory reason, for the most part, you can be let go, but severance has to be paid.
So going forward, wrongful equals money. That's right.
Good way to.
Wrongful
we're going to print
money.
some shirts, distribute those. Yeah,
that's
I agree.
Right. All right, 5 common employment law myths. Number 2 is this: time off work due to illness or injury can result in a termination of your employment.
And I know a lot of people are afraid and they believe, well, if I'm off work, my employer can just let me go. If I have a medical condition, I'm off work. Wrong, false. And employers, by the way, believe that too. You cannot be let go because of your medical condition. You cannot be let go because you need to take a lengthy absence as a result of that condition. You can be off as long as you need to if you have your doctor's support, knowing that you cannot be punished. And I've seen many situations where someone is dealing with a serious medical issue and they've had to be off for a long time, sometimes a year, 2 years, or longer than that. So even in those situations, your employer can't say too bad. Now, if it's time for you to come back to work, your employer then has to make all efforts to bring you back, to look for either the same job or a similar job. And if they've tried that, if they've looked, if they've made all efforts to bring you back, and there's just nothing for you, then and only then can they let you go, of course, with your full severance. But don't ever be concerned that just because you're sick, you can be let go illegal, and that's a myth.
It's that whole thing with, Lior, what happens, but I only have 10 sick days, so after 10 days, I'm done. I can't take any more time off. I've been told to get back to work.
Yeah, and I see that often. So the amount of sick days that you have or that your employer gives you has to do with how many days the company will pay you while you're off. So if you have 10 sick days, that means your employer is going to pay you for 10 days while you're sick. But that has nothing to do with how many days you can actually be off work. You could be off work for a year if that's what you need to get better and if that's what your doctor says. Now, you're not going to get paid by your employer for a year. They're going to pay you for the 10 days, but you can still be off for a year. You may qualify for other benefits, EI benefits, for example, EI sickness benefits, or maybe there's a short-term or long-term disability plan through work. But the number of sick days you have has nothing to do with how many days you can actually be off work because of a medical condition.
We are going through 5 employment law myths, very common ones. Number 3 is this: your boss can impose changes to your job at their discretion.
Well, the myth comes from the fact that, well, I work for the company, for the boss. Right. If the boss says, I'm going to change your job, well, what are you going to be able to do about it? He's the boss. Well, not so fast, okay? Your employer cannot make significant changes to the terms of your employment. So that is a myth, okay? Your employer cannot do that. If your employer does, that doesn't mean you can physically restrain them. You're not going to call the police and get them arrested. But what happens in that situation is you, the employee, have rights. You can make a choice. You can accept the change, or you can consider that to be a termination, a constructive dismissal, and leave with your severance. So I'm talking about a serious pay cut, usually 15% or more, changing of hours or shifts, a demotion. No, your employer cannot do that. That could easily be a constructive dismissal, even though he's the boss or she's the boss. Even though you work for them, they still cannot do that. They can't do that any more than you, the employee, can go and say, I've decided you're promoting me tomorrow with a salary increase. Thank you. You can't do that. Well, by the same token, they can come to you and say, I've decided that tomorrow you're taking a pay cut and a demotion. Can't do that. Constructive dismissal.
They have a little bit of leeway? A little bit of wiggle room?
So if a change is not significant, so a minor pay cut, a minor change in job or hours, they can get away with. Now, what's significant and what's minor depends on every case. So if you're not sure, is it constructive dismissal or can they get away with it? Well, rather than guess, call me. We'll talk about it and I can tell you, yes, it's legal, or no, it's not. So don't wonder and don't wait too long. If your employer is imposing a change and you take too long to deal with it, you're then considered to have accepted it, then you're stuck.
Okay, employment law myth number 4 coming up. A resignation is preferable to being let go from your employment.
John, you and I have talked about this many times, and I hear this consistently. In fact, back before I became a lawyer, I believe that as well. Well, of course, it's better to resign than to be let go. No, Nonsense, myth, not correct at all. There is no basis almost ever that being let go is somehow worse than resigning. There's no database. There's no big safe or big vault where the reasons for terminations are being kept. It doesn't exist. The only thing that happens if you resign is, number one, you make it much more difficult to get severance, maybe even impossible, and you also don't qualify for EI, for employment insurance. Whereas if you're let go, you get your severance, you get EI, and you're not worse off, you're far, far better off. So no, it's not better to resign. Now, the exception would be if you've done something terrible, you've committed fraud, you stole from the company. Well, yeah, sure, in that case, you may as well resign. You're not going to get anything anyway. But unless you've done something that bad, it is better to be let go. It's better to get your full severance, as much as 2 years' pay, and of course to get EI, which is a year's pay potentially. So no, don't believe that. And if your boss is telling you you have to resign, you tell them, no, I don't. Let them make the decision so that you can get what you're owed.
Okay, employment law myth number 5. We'll wrap it up for this topic with this one. This one's the biggest one. Like, we barely got this one inside the studio. It's so big, so common. Severance is typically calculated as a week per year of service.
No, false. Big, huge, massive myth. And there's other myths associated, that it's 2 weeks per year of service or it's something else. Wrong, false, it's a myth. And I know our regular viewers know this, but every week we have new viewers that are tuning in for the first time, so we have to emphasize this. No, if you are let go, it's not a week's severance per year of service or 2 weeks per year of service. The factors that go into deciding how much you're owed are your age, your position, and the length of your employment. And you could be owed 24 months. You could, as we talked about at the beginning of the show, you could have worked for a few months and be owed a few months severance. It's a heck of a lot more than a week per year of service. So go to pocketemploymentlawyer.ca, use our severance calculator, find out for yourself. If you've always been curious, but you thought you knew, I'm pretty sure it's a week per year. Well, don't do that anymore. Just grab your smartphone, go to pocketemploymentlawyer.ca and find out for yourself.
Before we get into a quick break, we're going to get to one more phone call from our radio show, so we'll do that right now.
Work for a huge company, and I've worked for them for approximately 10 years, and they eliminated my position, and they did offer me another position that is totally different from what I was doing, and I have a medical condition that prevents me from being successful in the job that they offered me.
Okay. What do you think?
Very, very good question. So what I would do in this situation is I would get a doctor's note that says, I can't do this job. I can't do this job properly. And at that point, then if the employer doesn't have another job for this person, they have to let them go and pay them severance. Because the concern would be if the employee just says, no, I'm not going to do this job, the employer is going to say, well, you've resigned. Not at all. Get a doctor's note. Now, when you get that doctor's note, your employer is going to have to see if they can find you a different job that makes more sense, that complies with your limitations. There's that obligation to accommodate. But ultimately, if there's no other job for this person, then they can be let go with full severance. You want to avoid a situation where your employer doesn't know that you can't do your job because of medical conditions. I know sometimes it's uncomfortable to give that doctor's note, but you have to do it. It protects you. It gives you rights. And if you do that, your employer can't just ignore it.
Let's grab one more break before we move on, and when we come back, it'll be working notice for long service employees. What is that all about? We'll discuss it and get into it after a short break here on the Employment Law Show. Stick around. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Thank you for sticking with us. Employment Law Show. Reach Lior anytime, 1-855-821-5900. Employmentlawyer.ca. That website will tell you so much, including reach out and how to find the radio shows across the country that Lior and I have been doing for nearly 10 years now. And we were younger guys when we started. Less gray, more hair, but, you know, that's a completely different show. We like to get some of the phone calls off the radio show. We play them back here, and we dissect them a little bit. You always learn something from doing that. So we'll get to our next phone call right now, Lior.
Calling on behalf of my wife. She's worked for a doctor for over 35 years, does everything in the office for him. She's office administrator. He himself has had some health issues in the last couple of years. But a month ago, he gave her notice. He is closing his practice. Some are telling her that she is entitled to severance.
The old doctor thing, eh?
Listen, I hate picking on doctors because doctors do such amazing work.
They keep us alive.
Certainly much more important than what I do. And I have some really close friends that are doctors that I love to death. But I got to tell you, from an employment law standpoint, they leave something to be desired. Okay, let's put it that way. And again, this is not a knock against anyone, but it's just the fact. So let's break this situation down. So this person, after 35 years, is going to lose their job, and they got a month's notice. Now, whatever severance they're owed, that month counts towards their severance. But the real question then becomes, after 35 years, that's a long, long time. Yeah. Does this person get more than just the month's notice? I mean, really, we shouldn't even have to answer this, but of course I will. Yes, of course, much, much more than just a month's notice. So I'm going to go back again to our severance calculator. Of course, you'll find that at pocketemploymentlawyer.ca. Free and anonymous always. Let's actually see, after 35 years at that doctor's office, what this person is owed. So office administrator, we know that 35 years of age, let's say somewhere in their 60s, was provided with 1 month's notice. We see the actual number there. And John, I think there's almost a glitch in the system here because it says 18 to 24 months.
No 18 there.
It should be 24 months, okay? You know, we're being a bit conservative. 24 months. Now, less than 1 month's notice. So the difference between 24 months and the 1 month offered is huge. It's massive. So that's the answer here. The same with you. You may have received advance notice of termination. Chances are, just like in that situation, that you're owed much more severance once that notice runs out.
There is yet another website for you to use anytime, free and anonymous, called terminationquestions.com. Again, we read some of those on the air. Lior, we'll get to this one. It says, prior to taking maternity leave, I was told I was going to be promoted to a senior position. Very nice. Now that I'm about to return from leave, my employer has informed me that the position has been filled. Can they do this, or were they bound to fulfill the initial promise? What do you think?
So it's a great question. Here's what I would say. They're not necessarily bound to fulfill that initial promise unless the reason they're not doing this is because she took a maternity leave. If the individual took a maternity leave and the company said, you know what, we're not going to promote her because of it, because maybe she'll take another one, or maybe she's somehow not reliable, that's illegal. Can't do that. In that case, it's a human rights violation. Now, if it's simply a situation where the needs of the business have changed, then they can do that. So the devil's in the details. But anytime an employer makes a decision about your job, your future, your compensation, because you took a parental leave, maternity leave, that's illegal. Can't do it.
Parental leave is that's the ultimate, you know, warning sign for any employer. They have the most rights, and you can't mess with them, right?
You really can't. And it's actually quite simple. I don't know why employers get this wrong. If you have an employee, father or mother, of course, that's taking a parental leave, you can't do anything to them. You have to let them take the leave. You have to let them come back to the same job, same compensation, essentially treat the situation as if that leave never happened. And anything less than that, it's an employment standards violation. It's a human rights violation. It's illegal. I still see these days employers getting this wrong. That shouldn't happen, John.
Unless they fire the whole department and you're part of that, then it's kind of beyond your control and theirs.
If it's nothing to do with the leave, absolutely. In most cases, I find that at least it's tied somewhat to that leave, John.
Again, terminationquestions.com is where we found that question. You can use that anytime you'd like. It's free. It's anonymous. Beyond that, you can always email Lior, help@employmentlawyer.ca, and always that phone number, 1-855-821-5900, and pocketemploymentlawyer.ca. You'll remember earlier, that's where you find the severance calculator, pocketemploymentlawyer.ca. Free and anonymous. Over 2 million people have tried it out, so you can as well. We'll catch you next time in the Employment Law Show. Thanks so much for sticking with us.